Hello everybody and welcome to our webinar. Today's webinar is part of Taylor Wessing's Data Protection webinar program, where we bring you our expertise and views on topical data protection issues. Those of you who are regular attendees to our webinars are going to be quite familiar with some of our previous topics. These have included data protection issues around particular technologies and developments, as well as challenges including, for example, CCTV, the use of connected data, managing cybersecurity risks, and direct marketing. Over the past year, the focus of a number of our webinars have been on key requirements and practical implications of the new EU General Data Protection Regulation, which is going to be coming into force in May in 2018. Recordings of our previous webinars are still available if you've missed them and you still wish to engage on those topics. Today we're going to be looking at different aspects of the compliance challenges the GDPR poses for employers, both in terms of the collection and the use of employee data. For those of you who are new to Taylor Wessing or new to our webinar program, then welcome. And as you'll see from the slide, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, and we provide a full service law firm offering from our office footprint that spans across Northern, Central and Eastern Europe, Middle East and Asia. In today's webinar is brought to you by our International Data Protection Practice. Our team advises on all aspects of data protection and on information law from our office footprint. And we're a global 22 partner-driven firm on data protection, and we're complemented also by an international network of data privacy law specialists. Hopefully you can see a slide now that shows that we have a dedicated microsite, the Global Data Hub, specifically that's dedicated to all things data protection. This provides news and weekly updates, and we also have a bi-monthly mail shot. It provides information around topical issues where we can take a look at issues that are raising concerns and challenges, and offers details of our forthcoming webinars, where you can also access the recordings of our archived webinars as well. My name is Sally Annero, and I'm a senior member of the London Data Protection Practice. And today's webinar is bringing together several members of our London Data Protection Practice and also some of our employment team specialists. And our slides include some profile information for you about them. So as I mentioned, today we're focusing on the GDPR from the perspective of employment data and the key challenges the GDPR presents for employers. But to begin with, my colleagues Colin Godfrey and Charlotte Jackson will be taking a step back, and they'll be looking briefly at the broader landscape of issues that impact on the processing and use of employee data. Following that, Debbie Hayward will be focusing in on the GDPR, and she'll be walking us through some of the key changes that this will bring for employers, and as well as looking at legal grounds for processing HR data under the GDPR. Following that, we will be turning to look at broader developments in the law, including the GDPR, and case law relevant to the challenging area of employee monitoring, particularly around that delicate balance when looking at employee communications between personal or private and the work and public. Stephanie Grieve will be considering the use of rights of data access in relation to employee data and the implications of certain case law and of the GDPR for the exercise of subject access rights in the employment context. And before concluding the webinar, we'll also be setting our usual polling questions around the topics that have been covered by the speakers. So we'll be able to share back with you in aggregate form the broader views and the approaches and views of the audience today. You can also send in questions during the webinar, and whilst I'm conscious that we have quite a packed hour of content for you, we will certainly do our best to get to as many of those questions we can in the time that we have available to us at the end of the session. But of course we can follow up with you separately if we can't get to your question this afternoon. So without further ado, I will pass over to my colleagues Colin and Charlotte.
Thanks, Sally. It's Charlotte here. So this afternoon I'm going to touch briefly on the General Data Protection Regulation, the GDPR in short, which, as Sally has already mentioned, comes into force on the 25th of May 2018. This will be the biggest change to EU data protection regulation in over 20 years, with the intention being to harmonise and modernise data protection laws in line with today's digital age. Debbie will be talking about the GDPR in some detail later on, but just to flag at this stage, the regulation will be expanding the scope of European data protection legislation, applying not only to EU companies, but also to non-EU data controllers and data processors. This is to the extent that they offer goods or services to data subjects in the EU or monitor data subjects' behaviour within the EU. From an employment perspective then, why does this matter? Well, any members of a HR team who are listening will know that they inevitably spend a good chunk of their time dealing with personal data, be it keeping the personal details of employees, details of their salary, their contract of employment, or dealing with grievances or disciplinary matters. The changes that the GDPR will introduce are therefore likely to have a significant consequence on how such personal data is dealt with by employers going forward.
So in the context of the GDPR, it looks like we've got a seismic shift on the horizon, but we've already had a data protection earthquake about 18 months ago in the context of international data transfers to the US from within the EEA. So global data transfers are often part and parcel of processing employee data, whether or not that's between an overseas parent, perhaps based in the US, and its subsidiary based in the EU, or it may just be that through the use of certain software, certain employee data software that's hosted on overseas servers, that you're actually transferring data overseas and into the US. So the duty, whenever you are processing data and sending it overseas, is that wherever it's exported outside of the EEA, the obligation is to ensure that there are adequate protections in place for the rights and freedoms of data subjects. Now, as far as transfers to the US are concerned, we had all thought that that was all fairly straightforward in the context of Safe Harbor, and up until 2015, October time, that was always the case. That essentially provided a framework for data transfers to the US and allowed US companies to sign up to certain Safe Harbor principles, and then for any organisation transferring data to those organisations to be satisfied that there were actually adequate protections in place. Then comes October 2015, and then we get the well-publicised decision of Maximilian Schrems and his claim against Facebook about the way they were processing his data. And what that essentially ended up with was the Court of Justice of the European Union declaring that Safe Harbor itself was unlawful. So then followed a number of months of uncertainty, and now we have in place the EU-US Privacy Shield. So this is a new self-certification regime which places stronger obligations on US companies that are handling EU citizens' personal data, again requiring compliance with certain core principles. But in spite of the fact that this is relatively new and relatively recently approved, there are still some concerns about whether or not it's actually going to last the distance. And actually there are some more challenges on the horizon. So unfortunately, there is some more uncertainty in the context of how data transfers between the EU and the US will be dealt with in the future. Now, obviously, speaking of uncertainty, you can't say uncertainty without talking about Brexit. Now, at the moment, that is probably the greatest source of uncertainty in the context of EU regulations, and given that both the GDPR and Privacy Shield are EU-originating instruments, what happens when the UK leaves? Well, from a GDPR point of view, that is going to come into force before the UK leaves the EU, and the UK government is expressly committed to its introduction. So really Brexit itself shouldn't actually affect the impact and the implication of the GDPR. From a Privacy Shield point of view, it's a bit of a different picture. So it now seems very likely that the UK, from what we've heard, is going to end up outside of the EEA, so outside of the single market, and that will mean it will no longer be party to the agreement that is currently in place in respect to transfers between the US and the EU. So what we may see is that there will be some separately negotiated terms between the UK and the US in respect of data transfers, looking at securing an arrangement, something similar to what Switzerland has got in place. But really the point is, I think, that there may well be some more changes on the horizon. So where does this all actually leave us, and what should you be doing? Charlotte, in the context of GDPR?
Well, Debbie will be going into further detail about this, but from an employment side, and what I'd recommend to anyone from HR who's listening to bear in mind, is that before we know it, the GDPR will be upon us. There's therefore no time like the present to be carrying out a HR data protection audit on the company's current policies and practices. You should really be considering what employee data is currently being held, why it is being held, how it is being used, and who it is being disclosed to. This may well involve a review of existing contracts of employment, staff handbooks, and employee policies, and considering which employees may require early training on the reforms. And this training really should take place sooner rather than later.
And then in the context of Privacy Shield, again, it's a similar principle of review, probably looking at your existing requirements for international data transfers, particularly those transfers between your organisations within the EU and the US. How are you currently managing that? How big of an issue is it for you? And then really, given the potential uncertainty that we've got at the moment, it's about thinking about alternatives. Is there the possibility in the context of intra-group transfers, so where you've got perhaps an EU-based subsidiary and a US parent, transfers of data between the two? Is it possible to adopt some binding corporate rules? It is a way around the requirements, but it is a notoriously cumbersome process, so one to just bear in mind. Alternatively, is there a way of adopting EU model contractual clauses, which essentially can provide a separate solution wherever you are agreeing terms with an organisation for the transfer of data to US companies? But given the extent of the uncertainty, it may be that we're actually, as a practical solution, thinking about alternatives. Is there a way in which actually we can avoid the need, the necessity to transfer data, personal data, from within the EU outside to the US? So that was all we were going to say as an introduction, and actually we're now going to pass over to Debbie, who's going to look in a bit more detail at the GDPR and what it means for you.
Thank you both. Yes, I'm going to drill down into the GDPR. There's quite a lot of information and I've got a lot to get through, so I hope you stick with me. One of the main features of the GDPR is that it imposes a greater compliance burden on data controllers. For some member states like Germany, they may find some of the new elements more familiar than other member states like the UK, but really all HR functions need to look again at their obligations and at how to comply with them. So what's new about the GDPR? It brings increased employee rights. Under the GDPR, employees as data subjects have essentially greater rights. The good news for UK employers is that many of these rights are similar to those under the current UK Data Protection Act, or DPA. The bad news is that as a general rule, the GDPR expands the rights under the DPA, introduces a few new ones, and imposes significant penalties for breach. So in summary, under the GDPR, we're looking at the following rights for employee data subjects. They have the right to be informed, and this encompasses the obligation on employers to provide transparency about the use of their personal data. They have the right to access their data, which is similar to rights under the DPA, and encompasses the ever-popular subject access request. The right to rectification of data that is inaccurate or incomplete, and again, that's similar to the DPA. And the right to be forgotten under certain circumstances. Now, this is a new one. It's been heavily publicised.
In an HR context, it applies mainly where consent has been used to justify the processing of HR data, and I'll be talking about that more in a minute. Employees have the right to block or suppress processing of personal data, and they also have another new right, and that's the right to data portability, which allows employees to obtain and reuse their personal data for their own purposes across different services under certain circumstances. At the heart of the GDPR is the principle of accountability, and this is enshrined as a new principle into the statute. It's arguably a continental concept at core, but not necessarily a concept that the UK or some other member states will be that familiar with. And it requires businesses to demonstrate they comply with the data protection principles and explicitly states that it's their responsibility to do that. Now, what does that mean in practice? Well, employers are going to have to put in place appropriate measures to ensure they demonstrate and they comply with the GDPR, and that can include putting in place internal data protection policies, staff training, internal audits, and reviews of existing HR policies. They're going to need to maintain relevant documentation on their processing activities. In some cases, they may have to appoint a data protection officer or DPO, and I'll be talking about that in a second. And they'll have to implement measures that meet the principles of data protection by design and default, for example, data minimization, pseudonymization, or transparency, and allowing individuals to monitor processing and creating and improving security features. They're also going to have to start using data protection impact assessments, or PIAs, where appropriate. And as well as the obligation to provide transparent privacy policies, where an employer has more than 250 employees, it has to maintain additional internal records of its processing activities, and this is going to place further cost and administrative burdens on employers. It's important to understand that the GDPR is a change in focus from high-risk matters to more routine ones. Effectively, anything that impacts the data subject is relevant, and while parts of the compliance burden can rely on a risk-based approach, the full detail of the GDPR does have to be considered. Another feature of the GDPR, which may be new to UK employers, is the requirement to appoint a data protection officer, or DPO. Again, the concept of a DPO is arguably a Franco-German one, and something that German employers certainly are very familiar with. Under the regulation, DPOs have to be appointed by employers who are a public authority, will carry out large systematic monitoring of individuals, for example, online behavioural tracking, or carry out large-scale processing of special categories of data or data relating to criminal convictions and offences. The DPO role can be outsourced to external providers, but the underlying obligation is that the responsible individual must have expert knowledge of both data protection regulation and requirements, and of the practices and processes of the employer itself. This should be proportionate to the type of processing the employer carries out, taking into consideration the level of protection the personal data requires. Employers have to ensure that DPOs report to the highest management level, and that's usually going to be board level. They have to provide adequate resources to allow the DPOs to meet their GDPR obligations. They have to operate independently, and they can't be dismissed or penalised for performing their tasks. They have very specific rights and protections, including the power to insist on company resources for data protection matters, the right to access the employer's data processing personnel and operations, and express protection against dismissal or penalties for carrying out their duties. And this is going to be quite uncomfortable for employers because it effectively creates a protected class of employee. And US parent companies in particular are going to find that quite hard to get to grips with. There's not going to be a limit on the tenure of the DPO role, which again is likely to cause raised eyebrows among some EU employers. And employers should note that any organisation is able to appoint a DPO. It doesn't really matter whether or not the GDPR requires it. But where you're going to appoint a DPO, you have to ensure that they have the sufficient skills to discharge their obligations under the GDPR. Now, I mentioned data privacy impact assessments, or PIAs, which help organisations identify the most effective way to comply with their obligations. They're not a new concept, but the fact that they're mandatory under certain circumstances will certainly be new to UK employers. So employers will be required to carry out PIAs if their proposed activities are likely to result in a high risk to the rights and freedoms of individuals. This is going to affect various aspects of HR activity, particularly in the recruitment and post-employment arenas. It's easy to see how vetting and assessment activities in recruitment, for example, will trigger a PIA. We also have much tighter rules on breach reporting coming in under the GDPR. Employers will need to inform the relevant regulator of a personal data breach within 72 hours of becoming aware of the breach, unless they're able to demonstrate that breach is unlikely to result in a risk to the individual's rights and freedoms. While self-reporting has always been an option for employers to mitigate the risk of enforcement action, this has now become an obligation for arguably all but the most trivial breaches. In tandem, the ICO and other national regulators will also have increased investigation and audit powers and rights to require information and access to premises. As you're probably aware, the GDPR has real teeth, and this certainly helps focus the mind on compliance. Currently, fines under national member state laws vary, but under the GDPR they're going to be significantly increased across the EU, as I'm sure you're aware, and they're going to be levied on a two-tier basis. So we're going to see potential fines of up to 2% of annual worldwide turnover of the preceding financial year, or 10 million euros, whichever is greater, and they will be for violations relating to internal record keeping, data processor contracts, data security, data breach notification, data protection officers, and data protection by design and default. The higher tier of fines, that's up to 4% of annual worldwide turnover, or up to 20 million euros, whichever is greater, will be for violations relating to breaches of the data protection principles, conditions for consent, data subject rights, and international data transfers. In short, that really means that employers who've previously looked at non-compliance with EU data protection law as a low-risk issue are going to have to re-evaluate their position. Multinational employers also need to look closely at developments in other member states, for example Germany, where lawmakers have already stated their intention to make use of the GDPR derogations for employee data protection. Some member states may raise the bar for local HR operations in certain areas and, for example, may introduce lower thresholds for appointing a DPO and determining specific conditions for processing of a national identification number. This is quite a lot to take on board. Employers need to take notice of the ways in which they process employee data, the purposes for which they process it, the processes and the procedures in place for collecting, transferring and storing it. Now, so far, the UK's ICO has taken a pretty pragmatic approach to enforcement, and we think it's unlikely they're going to change that. Maximum fines are likely to be imposed only as a last resort, but other regulators may also have a say in enforcement against UK businesses, for example, where it's primarily their own citizens who are impacted, and this means that the decision about enforcement may not be down to the ICO alone. In order to tackle the requirements under the GDPR and best protect the business, we recommend the following steps. First of all, review current data protection policies and practices. Allocate appropriate resources to deal with the enhanced compliance burden. Review employee data flows, use of employee data, and ways in which data is processed and stored. Put in place updated or new internal policies. Make sure your staff have adequate training. Conduct internal audits. Assess business needs and identify employees who will require early training with a view to rolling out revised data protection training for all employees nearer to the date of implementation. Where appropriate, you're going to have to appoint a data protection officer. You will need to use PIAs where appropriate. You'll have to implement measures that meet the principles of data protection by design and default. And you need to review and implement policies for reporting data breaches, and these should tie in with whistleblowing procedures. I'm going to move on now to lawful processing of HR data under the GDPR. In this section of the webinar, I'm going to be talking about the core principles of the GDPR, and these really set out the parameters for compliance. I'm going to focus particularly on the grounds for lawful processing, and these have some significant issues for HR data. Under the GDPR, personal data must be processed in accordance with certain principles, and these are broadly similar to those under the Data Protection Directive and consequently the Data Protection Act. As I've just mentioned, they centre around the concept of accountability. For HR teams, traditional justifications for lawful processing of employee data may have to be revisited, together with the way in which the data is collected, used and retained. So looking at more detail at the data protection principles, The GDPR requires data to be processed fairly, lawfully, and transparently. The data controller has to provide the data subject with information about his or her personal data processing in a concise, transparent, and intelligible manner, has to be easily accessible and distinct from other undertakings between the controller and the data subject, and it has to use clear and plain language. For employers, transparency is achieved by keeping the employee or prospective employee informed, and this should be done before data is collected and where any subsequent changes are made. It's important to remember that data is not always collected directly from individuals, but may be derived from other data sets observed by tracking or inferred using algorithms. The GDPR has a mandatory list of the information which has to be given to individuals where data is obtained directly from them, but also where it's obtained indirectly. Giving an employee or candidate a genuine choice about data processing in order to rely on consent is going to be an issue for employers in achieving lawful processing, and I'm going to be talking about that in more detail in a minute. Processing personal data is only permissible if and to the extent it's compliant with the original purpose for which data was collected. If you process for another purpose later on, that requires further legal permission or consent, and the only exception to this requirement is where the further purpose is compatible with the original one. Indications for this will be any link with the original purpose, the context in which the personal data has been collected, the nature of the data, the possible consequences of intended further processing for data subjects, or the existence of appropriate safeguards. The data minimization principle requires that data controllers ensure that only personal data which is necessary for each specific purpose is processed in terms of the amount of data collected, the extent of the processing, the period of storage, and accessibility. Under the GDPR, data has to be, and I'm quoting, adequate, relevant, and limited to what is necessary in relation to the purposes for which they're processed. And this links back to the purpose limitation. Employers need to make sure they collect enough data to achieve their purpose, but not more than needed. Personal data also has to be accurate and kept up to date, and that's going to be familiar from the DPD. Inaccurate or outdated data has to be deleted or amended, and data controllers are required to take, and again this is in quotes, every reasonable step to comply with this principle. Once you no longer need personal data for the purpose for which it was collected, you should delete it unless you have other grounds for retaining it. This means there should be a regular review process in place and methodical cleansing of HR databases. Under the GDPR, like the DPD, personal data has to be protected against unauthorized access using appropriate organizational and technical measures. This goes to the heart of protecting the privacy of individuals. Data controllers and processors need to assess risk, implement appropriate security for the data concerned, and then crucially check on a regular basis that it's up to date and working effectively. There are strict breach reporting provisions in the GDPR, as we've mentioned, with large fines for non-compliance, so this really is very important. The final principle under the GDPR is the one of accountability, which I've already talked about, and we've discussed what this means. So I'm going to look now at lawful processing, and that brings me back to the first principle that requires personal data to be processed lawfully. And this is really important because there are some changes for HR teams to take on board. One of the commonly relied on grounds for lawful processing of HR personal data under the DPD is that it is done with employee consent. Under the GDPR, consent must be freely given, specific, informed, and unambiguous. Given the imbalance of power between employees and employers, it will be difficult for consent to be freely given, which means it's unlikely to provide a valid basis for processing HR data. The GDPR explicitly states that account must be taken of whether the entering into of the contract is made conditional on the consent of data processing, where it is not necessary for the performance of the contract. In addition, in recently published draft guidance on consent, the UK's ICO has said, and again I'm quoting, it follows that if for any reason you cannot offer people a genuine choice over how you use their data, consent will not be an appropriate basis for processing. This may be the case if, for example, you are in a position of power over the individual. For example, if you are a public authority or an employer processing employee data. Now, it is possible to envision situations in which an employee does have a genuine choice and is able to withdraw consent concerning some of the data processed about them, but these are likely to be extremely limited, and employers should be very careful about relying on consent in order to legitimise the processing of HR data. A term in a standard employment contract will certainly be insufficient and will no longer provide a fallback justification. Employers should also note that where consent is used as the basis for lawful processing, the data subject has the right to have their data erased under the new right to be forgotten, unless there are other legal grounds to justify the processing. Other circumstances in which an employee can request deletion of data include where it's no longer necessary for the purpose for which it's collected. And this really means altogether that employers should look to other grounds for lawful processing in order to justify their processing of HR data. As the ICO's draft guidance states, if you are processing employee data, you should look to another basis for processing, such as legitimate interest. Now, there is a slight qualification to all this, in that the guidance is still in draft form and won't be binding, and we're yet to hear from other EU regulators or the Article 29 Working Party on the subject of consent in an employment context. Business located or with offices in other member states will need to keep an eye out for local developments. For example, Germany is currently discussing a general written form requirement for employee consent, which would further raise the bar for national operations and would certainly make multinational concepts even more challenging. But in doing so, they seem to be taking a more positive view of the possibility of valid consent in an employer-employee relationship. In terms of special or formally sensitive personal data, any consent to processing has to be explicit. This isn't a defined term in the GDPR, although the ICO's guidance suggests that it means in words. But in the context of HR data, valid explicit consent is going to be very difficult to obtain, and employers will most likely have to rely on the derogation in the GDPR on Article 92B, which relates to the processing of special data in an employment context. Another frequently relied on basis for lawful processing of HR data is that it is in the legitimate interests of the business to do so. Under the GDPR, processing will be lawful where it's necessary for the purposes of the legitimate interests pursued by the controller or by a third party, except where those interests are overridden by the interest of or fundamental rights and freedoms of the data subject, which require protection of personal data. Until recently, the equivalent provision in the DPD was heavily relied on by employers to justify data processing, but recent case law from the Court of Justice of the European Union has made it clear that you can't just argue that you've satisfied the legitimate interest test because it's in your economic interest to process the data. However, in the ICO's draft guidance, commercial benefit can be sufficient to count as legitimate, unless that's outweighed by the harm to the individual's rights and interests. The ICO cautions that part of ensuring this will involve being fair, transparent and accountable. So, for example, there may be a legitimate interest in monitoring employees, but in order to help ensure that the employer's interests are not outweighed by the rights of the employees, there must be full transparency about what monitoring takes place and for what purposes, together with appropriate safeguards. Processing will also be lawful where it's necessary for the performance of a contract to which the data subject is a party, or in order to take steps at the data subject's request prior to entering into a contract, which includes employment contracts, and where it's necessary to comply with a legal obligation. And these grounds are very helpful to employers, but they should remember that the purpose limitation and data minimization principles will apply and may have a bearing on how much data has to be collected and what it can be used for. Although the GDPR provides a more uniform approach to ensuring data protection compliance, there are, of course, permitted derogations, and one such example is Article 88 of the GDPR, which allows for member states, by operation of law or collective agreement, to provide more specific rules to safeguard the processing of employees' personal data within the employment context. The article further sets out that this may be in relation to data processed for a variety of purposes in the employment cycle, from recruitment to health and safety at work. The extent to which member states choose to exercise these derogated powers to reflect their current practices or to strengthen protection around employee personal data remains to be seen. Member states have to tell the Commission if they plan to take up this offer by the 25th of May 2018, so the clock is ticking. So what does all this mean in practice? Well, employee consent to the processing of their personal data is unlikely to be held to be valid under the GDPR. So employers have to begin looking now at grounds on which they have processed HR data to date and consider whether those need to change under the GDPR. The most likely ground for lawful processing of HR data will be that it's in the legitimate interest of the employer to do so. In order to ensure that the rights of employees are not unfairly compromised, there must be full and transparent disclosure of what data processing is taking place and for what purposes. While identifying an alternative lawful ground for processing is unlikely to be difficult in the employment context, the purpose limitation and data minimization principles may restrict the range of employee data which can be collected and what the data can be used for. Employers will have to give careful thought to each separate category of employee data they process and record the grounds for lawful processing upon which they rely in each case. Now, at this point, it's worth mentioning the concept of pseudonymization as a potentially useful tool for HR teams. The GDPR introduces this concept into legislation for the first time, and it means that the processing of personal data is done in such a way that it can't be attributed to a specific individual without additional information. Pseudonymous data is still treated as personal data, but it may potentially be subject to fewer restrictions on processing if the risk of harm is low. And it requires that the key necessary to identify data subjects from the data is kept separately and subject to specific security measures to prevent inadvertent re-identification of individuals. Currently, the process around pseudonymization is varied across the EU states, which is unhelpful for multinationals. EU-wide guidelines to add detail to the GDPR provision are expected, and they should help employers navigate this area. So employers should keep these practices under review. Again, let's finish by looking at what employers are doing. I think the message we're giving out is essentially very similar in relation to all the aspects of GDPR compliance, but it is worth reiterating. The new regime is complex, and HR teams should undertake careful review and planning ahead of the implementation date in May 2018. And in relation to compliance with the principles and lawful processing, they should be reviewing current data protection policies and practices, including existing employment contracts, staff handbooks, employee policies. They should be ensuring that there's full transparency over the nature of HR data processing in terms of the data used, the purposes for which it's used, and where it's processed. Where you've relied on consent to justify processing of HR data, consider an alternative and make sure that's recorded. Consider the geographical span of the business. Also note that EU member states have indicated they may put special, more stringent requirements in place under the GDPR, although we're not aware that that's going to happen in the UK. You should assess the business needs and identify the employees who will be requiring training. I mean, this is true this is true of all aspects of compliance, really, and I talked about it earlier. And crucially, you need to appoint someone within the organisation to oversee compliance with the reforms. And these are all going to be part of a very wide-ranging data mapping exercise that HR teams should be carrying out. I think that's everything from me for now, and I'm going to hand over to Steph.
Hello. So turning to one of the more contentious areas involving employee data, employee monitoring. Now, this is normally, or most commonly, a balance for employers between ensuring that employees are performing their duties and not exposing the employer to risks or wasting time, as against the individual rights of privacy and under data protection. Since most typical forms of monitoring, things like intercepting and archiving employee emails or tracking internet history, are considered to be processing personal data, these activities must comply with data protection principles. The Employment Code issued by the Information Commissioner to assist employers is a really useful source of non-binding guidance in this, but employers will also need to navigate other legislation, some of which we've referred to in the article, but things like RIPA and European Convention on Human Rights. Now, another piece of legislation that employers will need to consider is the GDPR, which we've already touched on in quite a bit of detail. It doesn't explicitly change the rules on employee monitoring, but there are a number of provisions that will make it more difficult, and as Debbie's picked up and really highlighted, the issues in terms of breaches are much more severe under the GDPR. Now, employers rarely seek consent for monitoring, mostly because the likelihood that it will be withheld, and some currently try and get around this by using implied consent. As we've touched on already, valid consent is going to be much more difficult to achieve in an employment context under the GDPR, and for sensitive activities like monitoring, this is especially true. Employers will need to look for other bases to justify the processing, most likely justification on an alternative ground, such as legitimate interest, as Debbie's mentioned, or legal obligations to maintain the security of employee data.
Monitoring carried out by non-EU entities is also going to be a problem, particularly in the example of a US parent with EU subsidiaries. There is no carve-out for monitoring, unlike for goods and services. And the general principle is, if you monitor UK activities or activities of EU employees from the US or anywhere else outside the EU, this data is going to be subject to GDPR obligations, and breaches will be subject to the severe penalty regime. Employee monitoring is also likely to be considered as a high-risk processing activity, meaning that a detailed privacy impact assessment must be undertaken and documented. Now, as Debbie's mentioned already, while the GDPR will go some way to harmonising matters in the EU, transnational employers are going to still find that there is some disparity between EU regimes, with some applying greater restrictions. And we've touched on Germany already, where it is a criminal offence for certain breaches already, and it has indicated that it may impose greater restrictions than those already under the GDPR where possible. One of the points to pick up, particularly in relation to the EU and in the context of employment, is the duty of trust and confidence that's implied into an employee's contract of employment. Now, that's going to be really, really relevant in the context of monitoring activities, because these may constitute a breach of this duty depending on the circumstances. And that's where telling employees and warning them that you're monitoring and what the consequences will be is really important. If you're thinking of taking disciplinary action against an employee, the concept of fairness and unfair dismissal risks is something that's really relevant, as are the procedural requirements under the ACAS Code of Practice. And likewise, employees who feel that they've been unfairly targeted by their employer's monitoring activities could also have a claim if they've been discriminated against or picked on, or they feel they have because of a particular protected characteristic or because of whistleblowing, for example. An additional problem that you've probably come across is that employees don't often distinguish between personal and business-related communications, even though employee handbooks may very clearly say they should do. And this creates a host of issues for employers trying to legitimately monitor business emails. So turning to this issue of informal communications, despite wild media reports, and you may have seen some of them, the Barbulescu case, which came up recently, which is the employee who was caught using a work-related Yahoo Messenger account to send intimate messages to his fiancée and brother, it simply restates the existing case law. In effect, employers can access private communications, but only where there has been an element of pre-warning to the employee and where the premise of the intrusion is a legitimate one. Now, in this case, the European Court of Human Rights held that the monitoring of the employee's internet activity and the use of the Yahoo messages in a disciplinary proceeding was proportionate interference with his Article 8 right to privacy, and it wasn't unreasonable for an employer to want to verify that employees were working during work hours, even where no actual damage had been alleged. The court was clear, and this is a really key point to take home, is that warning the employee was key. And they've been very, very clear as well that where there's no pre-warning to employees, an Article 8 right may be breached, even if the purpose of the monitoring was legitimate. So it's really important to be telling employees where you're monitoring, what you're doing, and what the purpose of that monitoring is. At the moment, under current UK employment law, employers can rely on historic emails as evidence of prior acts of gross misconduct as the most common example. Now, how this is going to fit with the increased obligations under the GDPR, particularly with regard to transparency and consent, remains to be seen, and there are likely to be difficulties. But that said, as long as employees have been clearly informed, and that's the key point again, and employers can justify the monitoring and related processage, storing, and other handling of data, and Debbie's mentioned the issues with having to delete data or remove it after time, any such risks should be limited, and it may actually in practice pale into comparison when balanced against other commercial interests of the business. Now, another issue that we see coming up on a regular basis is use of and monitoring of non-work related social media. A couple of the cases we've picked up, the Game Retail and Crichton cases, are probably the most high profile. There are many others. It's a particularly active area at the moment, and it's looking at the difficulty in distinguishing between private and work spheres. The Game Retail case sticks in the memory simply because of the tweets that the employee issued, which involved lots of abuse held at caravan drivers and golfers and various other Newcastle United supporters came in for quite a lot of abuse. In this instance, the tribunal and EAT struggled with the concept of what was private and what was work-related in the employment sphere, and very little, if any, consideration was given to data protection and privacy expectations. It would be tempting to speculate that the outcome might be different under the GDPR, and it is certainly something to keep in mind. So, with all of that information, what can you be doing? Well, the starting point is that you can still monitor employee activity. You just need to be careful about the lawful basis for it, how you communicate that monitoring to employees, and how you treat the data that's collected. As good practice, employees should be fully informed as to what monitoring takes place and why. Covert monitoring is really only justified where there are grounds for suspecting criminal activity. It's risky otherwise. Employers should be putting in place clear policies with regard to monitoring communications, and these should also be communicated and report to the attention of staff members. And that's really key. You want to be basically building a case where employees cannot be saying, I didn't know about that, or that it looks like a really difficult argument to run. Where you need to, make sure that access to the information you collect is limited to those who need to have access, and that they've been given appropriate training. Monitoring should be, as a basic principle, limited, targeted, and time-bound. Monitoring of the content of emails, for example, should be proportionate to the purpose that you're trying to achieve. And you should have regard for private communications, particularly where they're clearly personal, for example. Where relevant, you should be consulting with employee unions and work councils. Now, with regard to methods of communication not traditionally found in the workplace, so things like instant messenger and chat functions and WhatsApp communications on a work device, you should be setting out clearly what your expectations are with regard to privacy and employee behaviour and what monitoring will take place. You should be making clear that any communications using employer devices or these communication methods may be subject to monitoring and used as evidence of inappropriate behaviour, criminal activity, and so on. You should be carrying out privacy impact assessments prior to any monitoring and considering alternative or less intrusive ways of achieving the aim that you're trying to get to in protecting your business. The fundamental principle is really you should be open with employees, and if you feel uncomfortable about telling them how exactly you intend to monitor them or what you intend to do with it, it's probably that you don't feel you have sufficient justification for doing so. And by being transparent, you're likely not only to help protect that crucial relationship of trust and confidence, but you're also going to be able to evidence compliance with accountability, information and transparency obligations under the GDPR. Now, turning to subject access requests, which again are a slightly touchy subject and are going to be, unfortunately, under the GDPR as well. SARs generally and potentially give employees access to a wider range of documents and information in addition to or in conjunction with traditional disclosure in the context of litigation. They're a simple and cost-effective way to be difficult and to increase employers' use of resources and costs. So they're often used tactically, and this probably is where you see it come up the most. Now, while it might be tempting for employers to dismiss SARs as not relevant to employment litigation, a couple of cases recently, and particularly the Citibank case, suggest that tribunals are becoming more aware of employee data rights and data obligations and less receptive to arguments of SARs being used as a fishing expedition. In the Citibank case, the individual communicated with individuals at other banks via an online chat facility, and this involved disclosure of confidential information. She submitted a SAR shortly after she was suspended during disciplinary proceedings, which the employer rejected. She went back and narrowed the scope of the request, and again it was rejected. The ICO hasn't ruled on this matter yet, but the key point to note is that the Employment Tribunal held that the dismissal was unfair on a procedural basis, with specific reference to Citibank's treatment of the SAR. In essence, the finding was that Citibank's refusal to comply with this SAR contributed to the material unfairness of the process, since it had a material effect on the ability of Miss McWilliams, the employee, to defend herself in disciplinary proceedings. Now, this should be food for thought for HR teams dealing with these types of issues, particularly in light of the GDPR and the sanctions regime that's coming in. Unfortunately or fortunately, depending on who you are, under the GDPR, SARs are here to stay, and if you are hoping for a limitation on the regime, you're going to be unfortunately disappointed. The applicable rules and penalties are much more onerous than under the current Data Protection Act and what's currently in place. The current fee of £10 will disappear, as will the excuse or the grounds at least to try and delay responding to a SAR, and the 40-day time frame for responding is going to be reduced to a response within at least a month and without undue delay. There are extensions available, but it's very limited. There is no restriction on the number of requests or on the regularity of requests, and the first copy of any SAR outcome must be provided free of charge. Data must also be provided in a structured, commonly used and machine-readable form. We don't have any guidance on what that means yet, but it does mean that if you were planning on sort of data dumping on an employee to try and get around a SAR, it's going to be quite difficult to do. And the exemptions providing data in response to a SAR are also going to be much more limited. And if you've had to deal with them already, you'll know that that's not particularly good news. So what can you be doing again with this? The increased penalties attached to a SAR and breach of a SAR mean that employers need to be more prepared than ever under the GDPR. So you should be identifying who is responsible for responding to a SAR and making people aware, having in place an appropriate policy and procedure to deal with a SAR response efficiently, and providing sufficient training to those who are responding. Document, and we can't stress enough that you have to document response and steps taken to respond, and make sure, on a practical note, that you clearly identify deadlines for responding so that you stay within those obligations. On a practical note, the process should be designed to cause as little disruption to the business as possible, and think about helping yourself in defending any relevant employment claims further down the line. A couple of things to flag it to be aware of are onerous requests or requests for non-data protection related purposes. These have traditionally been areas where employers have resisted responding to a SAR. There is no protection under the GDPR for doing so, and as you'll know, particularly if you've had to try and use it's not a data protection relation excuse for not responding to a SAR, you'll know that's quite difficult to do anyway. It's not going to be any easier under the GDPR. And if you aren't responding, you aren't complying, you need to be aware of the sanctions that may be imposed, and that might affect somewhat your risk assessment of how you respond to the SAR. The thing to take away really is that SARs aren't going anywhere and now come with additional obligations on employers, coupled with the significant sanctions for breaches. Now, all of this is going to mean in practice increased risk and cost for employers. It's good news for employees seeking to use SARs, but it might also affect, as an employer, your approach to litigation and dispute resolution. And on that note, I'm going to hand back to Sally to have a look at the polling questions and a couple of the key issues that we've been touching on today.
Thanks a lot, Steph. So, as she mentioned, and as is tradition with our webinars, we now reach the point where we offer you the opportunity to share with us some aggregated information around practices within the audience as a whole, and we'll share that back with you based on the answers that we get to the polling questions. So the first of the questions, I'm going to read these out through first, all of them, and then you'll have a chance to respond to each in turn. The first question is around what proportion of your organisation's GDPR compliance programme currently focuses on HR data. So is HR data an equal priority with other data categories as part of your programme? Is it your priority because of the size of your workforce, for example? It actually is the main set of data that you're concerned about? Or in fact, is client and customer data your priority in GDPR compliance? Or do you have actually no focus on HR data at all as part of your programme? While you're thinking about that one, I'll move on to the next question, which is what reliance is currently placed on employee consent to justify processing? So is it the fact that, yes, in all of your employment contracts, for example, and in some policies you're currently relying on consent? Or is it that you've identified other bases for relying on a legitimate basis of processing, and you're in the process of making some changes to shift to that basis? Or is it that you've actually already moved away from consent as the basis for which you are processing lawfully employee data? And as you're thinking about that one, I'll move on to our third question, which is use already made of data privacy impact assessments for workforce data processing? Whether that's there's no current policy or process for PIAs, or whether you do have a policy and a process developed but it's not yet in use, or whether PIAs are already integrated with your data processing activities. And finally, whether you've noticed an increase in the use of subject access requests by your employees or former employees in recent years. So whether there's no noticeable difference, or a slight increase, or a significant increase, or whether you just don't have insight into those types of volumes, and so you can't answer that question. So we'll now move on to run through those questions for you, so that you can answer each of those in turn. And I think you should now be looking at the first of those questions: what proportion of your organisation's GDPR compliance programme currently focuses on HR data? And now we'll move on to our second question, as once we've confirmed we've got the figures back from that one. And now we're on to the second question. So this is what reliance is currently placed on employee consent to justify processing. So, as I say, I think this is probably going to be quite a big shift area for employers, because consent has traditionally been relied on very heavily in this area. It's interesting to see what percentage of the audience are already aware of this issue and are moving away from consent. Thank you very much. We've just got your answers for that one. And now we're moving on to our third question, which is use already made of data privacy impact assessments, or PIAs, for workforce data processing? As Debbie mentioned, although it's not a sort of a legal requirement as such, there is an element of presumption amongst data protection regulators that PIAs sort of form part of that compliance tool in your compliance toolkit, but the GDPR will formalise the requirement to undertake these types of assessments. So again, it'd be interesting to see what the current approach of our audience is to the use of these tools and how they're moving towards them. And then finally, we have our fourth question, which is around subject access. And this is really just to get a sense of whether or not you've noticed any increase in the use of subject access requests by employees or former employees in recent years. So whether there's no real difference, or a particularly significant increase. We're certainly seeing that the courts are dealing far more regularly these days with disputes which have used subject access in one form or another. So certainly, from the court perspective, we certainly seem to see an increased use in subject access in recent years. So let's now move on and look at the answers. So the first question was, what proportion of your organisation's GDPR compliance programme currently focuses on HR data? And an even split here, actually. So about 40% of you say that HR data has equal priority with other data categories, and 50% say that that the actual priority here is customer data. And I did wonder whether, in fact, that that might be the case. And interestingly, there's actually 10% have said that they have no current focus on HR data at all. So that's quite an interesting finding, and perhaps suggests the fact that that perhaps some organisations are making HR data a lower priority when it comes to their GDPR compliance. Moving on to the second of the questions. This was what reliance is currently placed on employee consent to justify processing. Very interesting here, 85% have said that, yes, in the employment contracts and in some policies, consent is heavily relied upon. And in fact, only 3% of the audience have indicated that they've already moved away from consent. So that kind of suggests that there's quite a bit of work here that will need to be done over the coming year to look at the legal bases of processing and to move to a sort of a new lawful processing reality. Then our third question was around is use already made of data privacy impact assessments for workforce data processing? And I'm not surprised here with the answer that 70% of you are actually not currently using a policy or a process for PIAs in relation to employment data. Again, I think to the extent where there is a focus on the use of PIAs, I think it's been perhaps driven to a certain extent by customer or subscriber or user data. However, 30% of you have said that PIAs are integrated with data processing activities already. So that's I say it's an indication that there's for the majority of employers, there's still some work to be done in integrating those procedures into employment data processing. And then finally, we had the subject access and the perceptions within employers of the volume of requests. And interestingly, 48% have not noticed any difference in the volumes of requests that they're getting. 16% have seen a slight increase, 12% believe there's been a significant increase. And I think that perhaps it reflects the fact that it remains the case that certain types of organisations are perhaps likely to get more subject access requests than others. And obviously also it may reflect on the size of the workforce of the organisation as well. I think may also have a factor to play in the volume of those requests that they get. So I'm conscious that we are now over our allotted time. We have had some questions in. We've had a couple of questions, I think, around retention of employee records. I know that Debbie touched on the retention point when she was talking about the principles and the GDPR. The broad requirement that you don't hold information for longer than is necessary will remain the same under the GDPR, and indeed what is necessary may, in the employment context, be driven by employment law obligations or Institute of Personnel Management guidelines around what is required. But certainly there will be no one kind of allotted period that requires you to hold an entire employee's data set for a particular period of time. You need to look on a case-by-case basis with a specific data set. So information about a potential recruit would not, or an unsuccessful candidate, for example, would potentially only need to be held for perhaps 6 months post the interview and application process, whereas information about a successful applicant and an employee may potentially be relevant for the life of that employee's relationship with you and beyond. But then even then within that, certain information may, during the life of that employee relationship, no longer need to be relevant. So retention came up a couple of times, but in relation to the other questions that we've had, we'll take a look at those outside of the webinar and we'll follow up where relevant with those who have posed questions that we haven't been able to get to today. So on that basis, it just leaves me to say thank you to my speakers today who've joined us to talk about employment issues and the GDPR. Thank you for joining us. We will be sending out details of our future webinar topic with you, and an opportunity will be sent for you to sign up to join us for that. But in the meantime, it just leaves me to say thank you and goodbye.